So what I'm actually going to do, because I was given completely free rein over my topic, is I'm going to talk to you about the state of the law with respect to children in British Columbia. And I will weave in stories about the work we're doing so you can see the contrast between what's happened traditionally and what happens when a lawyer gets involved. So I will give you a bit of a backdrop and we'll just take it from there. I work at the Child and Youth Legal Center. It's an initiative that's been around for almost 2 years now, and all of our work is really mirrored on the Convention on the Rights of the Child. So I will talk a lot about that. I have a bias. I think children should be represented when they want to be, and you're going to hear my bias, but you're also going to hear why I say that. So child representation isn't new. It's been around certainly as long ago as 1974. The Law Reform Commission of Canada said, where the interests of a child will be directly or indirectly affected by a court proceeding, consideration should be given to the appointment of independent legal counsel to represent the child. So this is back in the 70s. In 1989, the Convention on the Rights of the Child was adopted by the UN. Article 12 is the article that we primarily mirror our work on, Article 12 and Article 3, so I'll start with a bit about those. Article 12, a presenter, a professor named Nick Balla, who is the guru of family law, asserted that Article 12 is especially important because it's one of the few provisions in the Convention that actually provides for children's involvement. It's something where the children can actually exercise rights themselves, and they get to be involved in decision-making that's going to impact on them. What Article 12 says is every child, or it assures to every child capable of forming his or her own views, the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with age and maturity. In particular, the child shall be afforded the right to be heard in any judicial or administrative proceeding affecting him or her. So putting that another way, we should respect the views of children and youth, and we should include children and youth in matters that are going to impact on them. The right of children to be taken seriously constitutes one of the fundamental values of the Convention. So in Canada, every single province and territory has a way for children's views to be heard in custody and access proceedings. In British Columbia, so our province, the court has to consider their views unless it would be inappropriate to do so. In our province, there's a variety of ways that children's views are heard. So there's things called Hear the Child reports, there's experts who interview children, there's judges who will meet with children. Sometimes the child's views come in from their parents testifying about what the child told them. And it runs a gamut right up to full representation for children. Notwithstanding the fact that the court's supposed to consider it, and notwithstanding the fact that there's numerous ways for the court to consider the child's views, the reality is that in less than half of the reported cases in Canada that deal with custody and access, do they even mention the views of the children. So they're supposed to consider it, but they don't even mention it. The prevailing view in our courts in British Columbia, and mostly across the province, is that the appointment of a lawyer for a child should almost never happen. So why does this matter? Why can't we work with this process? Well, when a decision's being made in a custody case or a child protection case, a child's life is going to be profoundly affected by that decision. Who they're going to live with, who they're going to associate with, where they're going to live, where they're going to go to school, sometimes whether they're even going to see their parents. All of these things are being decided for that child. You're not going to find it surprising that what the literature says is children feel powerless in these situations of family change. Suddenly they're finding themselves often with almost no information about what's going on in circumstances over which they have little control and absolutely no say. They want to know what's happening and they want to be heard. They don't always want to decide, but they do want to be heard and understand how their views are going to be taken into account in the bigger picture. The Convention recognizes this, and its object isn't simply to protect children, it's to empower them. And I was thinking about that when Christine was speaking about empowerment is just so key. And I mean, I know I'm speaking to the converted, but it just makes sense that you empower the child. These are the people who are being affected. There's numerous paternalistic views. We hear, as lawyers, children don't know what's best for them. It's harmful for a child to expose them to the conflict. In my opinion, that's naive. These children are living this conflict. Where I'm working, we hear over and over again from children who say, my parents have been fighting about me for years and nobody cares what I think. So every province in this country has a different test on how and when a child can have representation in court. And British Columbia's test is far and away the most restrictive. So I will give you a bit of law, just to give you some context. Our Family Law Act says before a child can have a lawyer to represent them in court, the conflict between the parents must be so severe that it significantly impairs the capacity of the parties to act in the best interests of the child. So that's the first part of the test. And the appointment of a lawyer must be necessary to protect the best interests of the child. So in other words, things have to be really bad. Why would we as a society say it's okay to wait until things are really, really bad before we bring in a lawyer? And I can tell you from my own personal experience, one of the problems with that is we're walking into a mess. The lines are drawn. Everyone hates everyone. The child is living this. And now we're trying to bring some sort of sanity to an insane situation. So even if a child gets through this really hard, high bar, and a judge says they can have a lawyer, the child in British Columbia isn't entitled to a legal aid lawyer. So who pays for the lawyer? The court can appoint, well, the court can divide the cost of the lawyer between the parents. But I can tell you from speaking with the very few lawyers who've done that kind of work, the lawyers never get paid because the parents don't want to pay for the lawyer. It's just part of the whole conflict piece. So their only other option really is our center. We have 3 lawyers. We're building a roster of lawyers throughout the province. It's a small roster. We do the entire province. In child protection legislation, and we do less of that, and I'll tell you why as I go along here, but in child protection legislation, there isn't even actually provision in that act for a lawyer for a child. Children can be added as an actual party to the case, and that is done through a section of the act that isn't, in my opinion, designed to add a child as a party to the case. It's a section that says the court may add any person as a party. So it isn't child-specific, and it certainly isn't child-centric. If a child is added, and that rarely happens, the Director of Child and Family Services, who is that child's guardian while the child is in care, decides whether or not to provide a lawyer. Now, some people think once a child's made a party, they get a lawyer, but that's not the case. They may get a lawyer. They may get a lawyer to explain their rights at this point, and that's it. They might get a lawyer to represent them through the trial. Yes and no. It's not through. It's through the ministry's budget. The ministry decides it may or may not be administered by LSS, but it's through the ministry's budget. Sorry. So, and I can tell you my coworker who can't be here, but who read over my paper, didn't know that once a child's made a party, they don't necessarily get a lawyer. Whether or not they get a lawyer in part can depend on, according to the director, whether the social worker can explain the child's preferences to the court. So this isn't to advocate for the child, and it's not to agree with the child. It's just, can the social worker adequately explain the child's views. Bernard Richard, who was the former representative of children and youth, said, "In BC, lawyers are only ever rarely provided for children or youth in child protection or child custody matters, in complete violation of Canada's commitment to the principles of the Convention." So we'll contrast that with Ontario. In 2017, their child protection legislation had a complete overhaul, in part because of recommendations arising out of an inquest into the death of a child, which unfortunately is where most of our legislative changes happen in child protection. The Child, Youth and Family Services Act of Ontario has a preamble that says this: "In furtherance of these principles, the Government of Ontario acknowledges that the aim of the Child, Youth and Family Services Act 2017 is to be consistent with and build upon the principles expressed in the United Nations Convention on the Rights of the Child." So they have modeled their child protection legislation on the convention. The Act further mandates that when the court's determining what is in the best interest of the child has a list, and the very first factor listed is the views of the child. So they're taking it seriously. In my view, Ontario is light years ahead of us when it comes certainly to their legislative framework and their representation for children. So what's the value in hearing a child's view? The reality is children and youth can give you really valuable insight into the issues that the court and their parents are grappling with. It's often difficult for the parents to understand this because they themselves are so enmeshed in the problems and they're going through their own emotional pain. Understanding the child's views can often lead to fruitful and lasting settlements. And I'll share with you a few stories as I go on from the work I've been doing, and we've been doing at the center. I've anonymized this quite a lot, but the stories are true. In one case, a child's parents were sharing parenting time of the young boy when a job opportunity came up for one parent, but it required the parent to move to another province. From the parents' perspective, the only issue was, where's our son going to live? The parents' history was one of endless fights in court. Since they're almost 5 years since they separated, every single decision about their child had up to that point been made by a judge and not by them. This trial respecting this potential move had been set for several days of court time. They had drawn their battle lines, and the child, of course, was experiencing the anger that the parents felt, the fear of not knowing what the outcome was going to be, and of how this was going to affect him. The one thing, and probably the first thing since their separation they actually agreed on, was the child should have a lawyer. And the reason for that was probably not very altruistic. They were positive that each of them was right about what that child wanted. And the lawyer's going to come in, is going to talk to the child, and going to prove me right. So they retained me. This might not surprise you, but the parents also said, we will respect our child's wishes. So this child met with me several times, and that's a really important piece of child representation. You don't meet the kid once and go off and say what they said. I see it when I look through my interview notes, how the relationship develops and how we come to plan, and I would never meet with a client once and go do a trial. Why would I do that for a child? And that's an aside, but I see it in child protection all the time where if a lawyer is appointed, they will go to court and they'll say, Your Honor, I've met with the child once and this is what they tell me. And I'm like, are you kidding? You are seriously feeling that's representation? So this child meets with me several times and his views were far more nuanced than do I want to move. Through me as his voice, he was able to explain ultimately to his parents what he wanted and the reasons behind what he wanted. And what the parents got was some real insight into his emotional needs, his social needs, a number of things. And although the views were not what either parent had expected, they ultimately decided they would in fact respect their son's wishes. And it was quite interesting because one of the parents, when I told them the wishes at the trial, said, well, no. And then thought more about it and came up to me and said, you know, I said I would respect his wishes, and I'm going to. It was super empowering for the child, and it really helped both parents. And this marked for this family the very first time they left a courtroom with a decision they had made and not a judge had made. Since that time, because the problem with being a children's lawyer is you never close a file. So since that time, they continue to cooperate with respect to their son. And his life is better, and their lives are better. The judge in that case, just as an aside, told my husband that he owes me a bottle of wine. So I'm waiting for it. I prefer red if anyone wants to know. Now, Article 3 of the Convention is the other piece I spoke about. Article 3 requires, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration. And then according to the UN Committee on the Rights of the Child, they say there is a direct link between legal representation and the best interests of a child. Just to give you some background, I guess, which is something I've learned through the course of my work, after this convention was signed, there's a committee that meets regularly to ensure that the states who are signatories are actually compliant with what they have signed on to. And to that end, this committee publishes general comments. In general, the comment that comments on the relationship between legal representation and protection of the child's best interests, it says, the child will need appropriate legal representation when his or her best interests are being formally assessed and determined by courts or equivalent bodies. In particular, in cases where a child is referred to an administrative or judicial procedure involving the determination of his or her best interests, he or she should be provided with a legal representative in addition to a guardian or representative of his or her views where there is a potential conflict between the parties in the decision. So what this means is hearing the views isn't enough. A legal representative is in addition to someone who represents the child's views anytime there's any potential conflict between the parties in the decision. So if you look at child protection proceedings, the parties are the state on the one hand and the parents on the other hand. The state may be seeking to take guardianship from the parents temporarily or permanently. The child's best interests are the thing that is front and center, notwithstanding these are the parties. Having a social worker, even a really well-meaning social worker, explain the child's views to the court isn't compliance with the convention. And if you take a family law custody and access dispute, in that case the parties are usually the parents. And again, the child's interests are front and center. So clearly, in my view, the sheer fact that these parents are asking a judge to decide their child's fate highlights the fact there's a conflict between the parties. Just to retain a professional to speak with the child and present the child's views is not enough. According to the convention, the child is entitled to a representative of his views, that's the professional, and a legal representative to make sure the views are heard and considered, that's the lawyer. If you juxtapose the language of the potential of conflict from the general comments with the language in the FLA, which requires, and you'll remember back there I said not potential conflict, but conflict that is so severe that it significantly impairs the ability of the parents to act, well, clearly these don't match up. The language of the Family Law Act doesn't conform with the expectations of the Convention on the Rights of the Child. And the authors and the people who have said we're not conforming are right. We have to start with the understanding that children are rights holders. They are entitled to the same protection as everyone else is with respect to their rights. So what should child representation look like? It has to be transparent. It needs to be informative. Children should have full, honest, age-appropriate information about their right to express their views freely. They need to know as well how this participation is going to take place, what its scope is, what its purpose is, and what its impact might be. So what happens right now in British Columbia? Child participation often looks like this. Court orders a report to determine the child's views. a professional is retained to speak with the child. An appointment is scheduled and the child is taken to that appointment. The professional sits down, they talk to the child, they find out their views. Sounds great, except the child has no context. Children have told us they often don't even know they're going to do this day. They don't realize that they're about to exercise their one and only opportunity to freely express their views. They don't have information about what's going on in the court because we want to protect them from that. We don't want to draw them into the conflict. This meeting that they have is not a privileged, confidential one, and they might never see that professional again. Their views will be recorded, often word for word, and then there might be a brief follow-up conversation by phone just to confirm that this is what they said, that the professional got it right. And I can tell you, in my representation of children, I would never tell them what they told me. I don't ask leading questions. I let them tell me things. I would never ask a child leading questions. I would never say, in our last interview, you said blah, 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 blah. I would ask them about things, and I'll even say to them, I do listen to you. Some of the stuff I'm asking, you're going to say, I told her that already. But I will explain to them that I really want to allow them to speak, and so I would never do that. But in a Views of the Child report, the author will often, and I don't want you to leave here thinking I have a problem with the work these people do, because I don't. I think it's one piece, it's not the only piece. But they will often just read to the child, this is what you said, is that accurate? And they'll write it down, and they'll provide the report to people. So then that report is released, and it goes to the parties and to the judge. And that's if that child's lucky. If the child's not so lucky, an evaluative report is ordered. In that case, the professional sits down, listens to the child, and decides whether or not the court should give that child's views any weight at all. Unlike the child, this evaluator has full context. They've spoken to everyone. They've seen reports. They've done tests. They've done that all. So again, there's nothing wrong with knowing in a very broad way what's in the child's best interest. But why wouldn't we give the child that same protection? Why wouldn't we allow the child to know what's going on? This is the context, so that when they're making decisions, they're making real decisions. It's their future we're talking about. The other problem with the reports, in my view, is the children aren't told that the report's about to be released. So in another case that we saw, the report had been released. The child had no idea. Parent got the report, went to pick up the child to exercise his parenting time, was so angry about what the child had said that he sat the child down in the car and forced her to retract her views in writing. He then took her view and filed that with the court. This process completely devalued her views. It made her look like she didn't know what she wanted. From her perspective, she was defeated. She learned that her right to freely express her views was subject to her parents' approval. The other piece about reports is once a report is done, it could take months or years to get your trial heard. These reports can be dated. They might not reflect how the child feels now. How can that possibly be characterized as consideration of a child's views? So if you contrast that with a situation where a child has a lawyer, child meets with the lawyer several times. Often they find out for the first time. I don't know how many times I told a child what the court order says, because they don't even know. So they'll find out what the court order requires their parents to do, which is really what the parents are often going to have the child do. They learn what options there are, what the challenges there are, and they get some context. The meeting is privileged. And I really can't emphasize enough how important that is, because it gives that child the opportunity to express their views freely and in confidence, to make informed decisions with the benefit of legal advice. Yeah?
Just a quick question. When it comes to the duty to report, Do you explain that to them?
I do not have a duty to report as a lawyer. And what she's asked, I don't know if everyone knows, but in British Columbia, if a child tells you something, you'll probably phrase it better than I would, but if a child tells you something that causes you to believe that a child in British Columbia is in need of protection, you're obliged by law to report. If you actually read the subsection on that, lawyers do not have that duty. It is a truly confidential meeting. Just so you know, I have never come across a case where I even felt it was a problem. These children have reported. No one listens to them. But when they get to speak to a lawyer, they also have the right to change their minds. They also can work through their feelings of divided loyalty in a safe environment. And another significant piece is I'm going to work with them until the case is done. So their views and their perspectives have an immediacy that helps to really inform the process. The other piece is they have the right not to express their views, and they come to learn that. So in another case that we were involved in, the person's parents wanted to decide what school this child was going to attend. This decision was going to determine where the child lived and which parent she would end up spending most of her time with. The parents couldn't agree on it, so they decided to let the child decide with the help of a lawyer. At first, the child was very flattered. She felt she was being heard and she was being respected, and she would come in and she'd meet with her lawyer, and space was made to talk about the issues that she saw as relevant to her decision. She also at the same time got some understanding of her parents' challenges. After many meetings, she decided she did not want to decide. Through the process, her needs and her concerns were highlighted, and she asked me to make sure that whatever decision her parents made, they knew what her needs were and they knew what her concerns were. When the parents understood what she needed and what was important to her, they were able to make the decision, and again, we avoided a trial. This child was so relieved because she didn't have to choose between her parents, and the parents were relieved because the child didn't reject them. Children's views are entitled to be respected. They should be voluntary. And I can't emphasize enough, the right to freely express your view means the right to freely not express a view. The process itself has to be child-friendly in order to ensure the child has the confidence and the opportunity to actually express their views when they want to. Children, the right to be heard isn't without risk, and children even who come to see us will develop safety plans around when we can tell their parents certain things. They can sometimes delay sharing information. None of that happens if you take away the lawyer from the equation. When a report is just released, a child can come home and find out the report was released, and the child will have never even seen the report. A lawyer's job is to represent what the child's views are and not to substitute our own views for what we think the child should want or what we think is best for them. The child has a right to be advocated for, and the lawyer's role will fulfill that. In my view, this allows for accountability. It allows the child to know how their views are being interpreted. It allows the children to have the opportunity to challenge evidence and to influence the analysis that will lead to the final decision. The children should also know how a decision was reached and what considerations the judge thought about. They should have a lawyer who can appeal decisions when they are wrong. And how could that not be in a child's best interests? We settle most of our cases, and we only represent children in high conflict cases. The sheer fact of the lawyer who is seen by the parents as independent seems to really help. But not all cases will be settled, and having a lawyer through the process will keep that spotlight on the child. I'm going to end what I have to say here with a comment from one of the staff from our center. A lot of our staff are here today, and they play a huge role in the work we do, but they very seldom get the opportunity to actually see the work outside of the office. In this case, one of the staff went to court and sent us her observations. It was really great seeing our lawyer in court today, listening to her references, multiple case law, instructions from the children. I noticed how the parents kept it about themselves, their rights, their health, their desires, and addressed unnecessary, irrelevant arguments. But the decision that is going to be made is going to affect the children the most. Yet no one made it about the children. I can't imagine what it would have been like without our involvement. The only person that put the focus on the children, voiced their concerns and rights, was our lawyer. She was their voice. I know our services are important and needed. I know a lot of work goes into representing these children. Getting outside of the office and being able to attend court and seeing how it all plays out is very eye-opening and rewarding. Children have the right to be heard and have access to all the tools that are necessary to make that happen. As the Ontario Court of Appeal recently said, one of the most significant developments in family litigation affecting children is the recognition that the child has a voice. And in my view, as a society as a whole, we are responsible to make sure that that voice is not muzzled. So thank you.